Grant Gilmore there, worthy recipient, as you were just hearing there, of that latest award, the 2011 Ciara Glennon Scholarship for those worthy endeavours. Let's move on. And less than 6 months after the David Jones sexual harassment case hit the headlines, another large company is facing similar claims. I can tell you that an IBM employee, a female employee at IBM, claiming in excess of $1 million in compensation for sexual harassment, discrimination and bullying, and it's all based on the alleged conduct of a staff manager. Now, she's saying that that manager put his hand up her dress at a work function, made intimidating remarks and indeed unreasonable work demands. Well, for more on what employers should do to meet compliance with sexual harassment and bullying laws, I'm joined by none other than Joydeep Hor from People and Culture Strategies. Joydeep, just when we thought we had kind of seen the last of this, well, conduct unbecoming, if I choose and just indeed paraphrase some of that notable language from the David Jones trial. This is happening, but it's also throwing into stark sort of focus this idea that companies from day one of a claim being lodged have a lot to sort of answer for in the realm of public opinion.
Yeah, indeed, and we've had a number of conversations about where this whole area of law is heading, and I think this latest case marks a further signpost in the increasing level of responsibility that employers, senior managers and human resources practitioners within organisations have to address these issues proactively. What we're starting to see, probably for the first time in the last 12 months, more so than ever in Australia's history, is that these cases are going to be first and foremost played out in the public eye. Disappointing, some might say, because they are, from one point of view, intensely personal matters. Of course, only allegations at this stage, and there's always many sides to these kinds of stories. But often from an organisation's point of view, the horse is bolted and you're in recovery mode, and you're a big organisation. You've got many thousands of employees worldwide. You've got a brand, a prominent brand. And how do you recover the damage that might be being done to that brand through these kinds of incidents, even if it's the case that it's just one recalcitrant manager within the organisation?
Lots of open-ended questions you just raised there, principally being this idea that that old adage in PR land that the best response is a comment, not a no comment. You know, so from that point of view, what do you do in that period of time where we don't even know yet who this alleged victim is? Because until it gets to trial, that much is kept under wraps. The company, though, has to adopt some form of a proactive response, rolling response. What do you do in that time frame?
Yeah, I think the Human Rights Commission process in this country is meant to be an entirely confidential process, and I think for good reason. However, when matters actually go to the formal court system, it's completely the opposite, and there's a principle that these matters should be ventilated in the public arena. I think the legislature and the government have to take a very long, hard look at this whole area, because what we're seeing here is the anonymity of a complainant, but a very public scrutinisation of the employer, a large multinational in this case, and you can guarantee that even if it was to be the case that there was one employee behaving inappropriately, 99% of the workforce of this organisation are doing all the right things.
And it then becomes a very almost catch-22 situation, because you can't, in your response, presumably at that initial stage, begin to comment or reference or indeed rebut what's been alleged. That would be seen to be going outside the ambit of what's pending in a trial context, right? But then again, if you come out with the opposite extreme, which is merely PR pap about how wonderful your procedures are and how satisfied you are, people are going to be discounting that and becoming very cynical about that.
Exactly, and I think that employers, even with the best assistance from public relations experts in this kind of area, will struggle to come up with a line that both protects their legal position and their legal interests, but by the same token isn't seen to be ducking and weaving from important issues and important allegations. Now, the flip side of all of this, though, is, of course, as we saw in the David Jones case and in others, is that when it does go to court, and perhaps in the immediate lead-up, that there'll be a lot said about the complainant, inevitably, and there'll be a lot of scrutiny about their conduct, their practices, their history. It's damaging for a whole range of people involved. And
in fairness, though, that's something that their legal counsel is going to be making them all too well aware of, alongside the quantum of damages that's being sought. So arguably, the higher the quantum, the greater the onus to be absolutely watertight, that you can stand firm, because there's an awful lot riding on this for both sides.
Absolutely, and the vast majority of these cases do settle out of court, and if I was a betting man, I'd say that this one will too. Those settlements will be confidential in the general course of things. The difficulty that I have, and many practitioners have, is that with these big numbers being touted, are expectations being set in society that these matters, if they do happen in a workplace context, are effectively a goldmine for applicants.
Well, yeah, I want to address that one, because in fairness, if we can distinguish at this point, can't we, the David Jones lawsuit, where the amount sought was in the realm of about $37 million, and included in that a portion of punitive damages. So a real stick against the company, not just the individual who is against whom the allegations are being made. Here in IBM's case, you don't have that punitive dimension. Why not? Why do you suspect that's absent?
That's a matter for the lawyers who structured their case. They're focused more on established precedent whereby people are compensated for economic loss. They've got to the above $1 million figure, though, on the basis of, as I understand it, medical evidence to suggest that the impact of the behaviours were such that this complainant may struggle to work ever again. Now, that may well be the case. I can't help but think that that's a matter that's going to be pretty intensely tested by IBM's lawyers if the matter goes to court.
Indeed, as it arguably was in David Jones's case.
We'd never really got to be tested because of when the settlement...
and so we will arguably never know that. Tell me, though, about, by excluding it, how that almost gets off scot-free, or the perception around the boardroom table is less, I suppose, salutary there, therefore, at that point, because they're not being, as a company, singled out. Then, at the moment, in IBM's case, still comes down to one individual. Do you think that's creating a climate of complacency?
I do think, whether it's a climate of complacency or a failure by boards and leadership groups to properly appreciate that these things can happen and do happen within their own organisation. The mistake I think that senior executives are making at the moment is they compartmentalise these cases and really do apply this approach of, well, that is not the kind of behaviour that happens in this organisation. And what I challenge them to properly appreciate is that those behaviours, if not identical, very similar behaviours, and comparable in terms of how they'll be judged in the public eye, are occurring within their organisation. It's just that the person who is the victim, to use a terrible phrase, is not making an issue about it at this point in time.
Is that a generational denial, you suspect? So the longer the older guard sort of holds sway, there will be that, well, it's not happening on our turf. It's someone else's problem. But that's beginning to change. We've seen even this year key personnel around boardrooms hanging up their ties and all the rest of it. Do you think that will usher in a new environment?
Look, I would certainly hope so. I think that leaders who have come through a generation of a lot more compliance training in their formative years in the workforce will have a greater appreciation. Certainly those coming from a US background, from a corporate point of view, will have a better appreciation of these kinds of matters than those coming perhaps from a European background.
Would you also be liking to see, because it did throw into stark relief with the David Jones case, and arguably with this one now with IBM, the elevated role of HR, another awful phrase, human resources. But the fact that with David Jones you had a chairman arguably left out to dry, he was left hanging, was he not? Facing a barrage of reporters' questions without the support of HR alongside. Does that have to change? Do we need to be flagging the fact that they stand together as one?
I think the challenge will, perception-wise, from a board point of view, rest with HR to make sure that the house is in order. But in my experience, there's a lot of very, very competent senior HR practitioners and leaders who are trying to drive this but aren't getting the necessary buy-in. By the same token, there are a lot of HR practitioners who are perhaps not driving this as intensely as they should. And the I guess the critical catch point for senior executives and board members should be that you can be personally liable, and that's one of the features of the DJ's case that's been overlooked, was that board members were personally litigated against in that case. So that's a real risk, and if that doesn't get the attention of senior leaders within the organisation, then perhaps nothing will.
And you don't think that by codifying more strictly the role of HR in these situations, i.e. to be that policing mechanism, not simply a response mechanism, if you do codify it, you would then remove
This was the first time that they were taken to
Farmers, its shares down about 0.5%. It, of course, releases its profit results tomorrow or Thursday. I always forget. Anyway, the introduction of the Fair Work Act was designed to increase the rights of employees. The so-called general protections in the Act have recently been clarified by a decision of the full bench of the Federal Court. To walk us through what this means, particularly what it means for employers, Joydeep Hor is the Managing Principal of workplace law firm People and Culture Strategies. Joydeep, thanks for coming in. It's quite an interesting case, but I